Right. So hello, everyone. My name is Riley, and I am the digital and social media content analyst here at GBBC. And we would like to thank you all for joining this webinar presented by the GBBC Initiative, the International Journal of Blockchain Law, also known as IJBL. And for those who are not familiar with the IJBL, it is an open access online journal written and edited by lawyers and designed to help business and non-legal communities better understand the world of blockchain and digital assets. So as a quick reminder, this webinar will be recorded, and please feel free to submit your questions into the Q&A box below. So now I will turn it over to Andrea Tinianow, GBBC's Chief Legal Officer and Head of Policy Americas, to introduce today's session.
Thank you so much, Riley, and welcome everyone. We're so happy you could join us. This is going to be a intellectual discussion about some pressing issues. We're going to be doing a deep dive into an article called The Ineluctable Modality of Securities Law, Why Fungible Crypto Assets Are Not Securities. And that article was written by Lewis Cohen and his colleagues at DLx Law. Some housekeeping issues before we get started. The participants here have some great points to make and some terrific arguments that they will articulate, all of them. But it's really important to know that although they may be making these arguments, these opinions may not be arguments and opinions that they hold personally. So they're representing these ideas so that we can have a really good discussion and understand the relevant parameters for these various arguments. Before we get started, just a little bit more housekeeping here. The webinar is going to be broken into two parts. The first will be more of a fireside between Liz Boison from Hogan Lovells and Lewis Cohen. And then the second part will be a more point-counterpoint between Lewis Cohen and Stephen Palley. And that will be facilitated by Alan Cohn from Steptoe and Johnson. So I'm going to now turn over the panel to Liz and Lewis, and I'll let them introduce themselves and get started. And I'm going to recede from the screen, and I'll see you in about a half hour.
Excellent. Thanks so much, Andrea. And thank you, Riley, and everyone at GBBC for setting this up. My name's Liz Boison, and I'm a partner at Hogan Lovells. I lead our digital assets and blockchain practice for the Americas. Lewis?
Hi, it's Lewis Cohen here of DLx Law, and we're a boutique firm that focuses on this. And Liz, it's a special treat for me to be here with you. I was formerly a partner at Hogan Lovells. You guys have an amazing firm, an amazing blockchain practice, and it's a real honor to be able to talk with you today.
Well, thank you. Likewise, Lewis. So, I wanted to just dive right into the article, but before I do, sort of just reviewing some concepts. I imagine anyone who's tuning in for this has at least heard of the Howey test. A great deal of talk and ink has been spilled over it. Just quick recap, when we're talking about the definition of an investment contract, and I know that that's one of the things that you really love to highlight, is that standing on its own, the prongs mean nothing unless you're really defining an investment contract, which requires an investment of money in a common enterprise with a reasonable expectation of profits from the efforts of others. So when you've, got all four prongs of that met, is that even the right test? I think that digital assets in their various forms, including tokens, might not be amenable to that test. I think your article would say that that's not the right test. So, maybe we can dive in and talk a little bit, the ineluctable modality of securities law, why fungible assets, crypto assets are not securities. What would you say is the right test? Does it depend on an ongoing legal relationship? Is it something else entirely?
Yeah, it's a great way to tee things up, and thank you, Liz. I think it's important to remember, and this is the Global Blockchain Business Council, there may be people from other jurisdictions. Here in the United States, we do have a very principles-based test of what is or is not a security. And of necessity, with the principles-based test, there's always going to be some arguing around the edges. Long before digital assets ever came up, there were many scholarly articles articles, and they're sort of collected at the end of the paper, debating the question of what is or is not a security under the Howey test. So, we're not talking about something new here. As you said, what we're trying to do is take a new technology and see where it fits into this, 70 plus years of jurisprudence of how do you apply a principles-based test, or put it another way, how do we stop people from working around our definitions? There are policy reasons why we treat investments different from other commercial arrangements. And the question is, okay, but sort of where do you draw those lines? And there's always going to be fuzziness around the edges. I'd actually say, Liz, that in many ways, I think the Howey test not only has stood up very well over 70 plus years, it works just fine vis-a-vis digital assets when you read it sort of properly in the context of its history. So I don't particularly think we need to fundamentally change the Howey test for the purposes of crypto assets. I think, and we'll probably talk about this a little later, we can make some other changes to better provide investor protections than what we have today.
Fantastic. So, you talked about it can be the right test kind of at the right moment in the life cycle. When would that be? Is it capital raising transactions only? Are there any downstream applications, or is it really the sort of first purchaser and subsequent purchasers and secondary transactions, need not be bound by the securities law? Is it that something can morph in and out? Or how do we have a standard that can be applied throughout the entire life cycle?
Yeah, I mean, those are great and really the most fundamental questions here. Let's start, perhaps with the easier part of your question, which is, where do the securities laws apply? And talk about where they don't apply, right? So where do they apply? I think there's little or no disagreement in the bar, among regulators, or in courts that where two or more parties, at least we'll say two parties, enter an arrangement where one provides capital and the other provides some sort of managerial or entrepreneurial effort, where the capital provider is sort of seeking to make a profit from the other party's managerial entrepreneurial efforts and are just a capital return. They're not in a business as such. That's fundamentally an investment arrangement. What people have done since the original, of course, fact pattern of Palley, which was a company that ran hotels in Florida after World War II and invited people from the north down. And when they were down and staying at the hotel, they took them out to some orange groves and said, man, look at those trees, look at those oranges. Just imagine how many people want to buy orange juice. You can make a lot of money here. How about you buy a little piece of land here? You don't need to worry about the picking part, we'll take care of all that stuff for you. You're going to make a nice return. What's not to like? That kind of a pitch, even though securities are never mentioned, you're not buying equity in a company, you're not doing anything, but that arrangement, that fundraising activity, courts have found, generally speaking, that's investment activity. The second, that's the easier part. And it doesn't really matter what is being pitched. And in the article, we go through, myriad examples of, human ingenuity, whether it's chinchillas being grown for their pelts or whiskey being aged in barrels or many, many other sort of odd sort of arrangements. All of those fundraising activities are securities transactions. The catch, Liz, is that over time, most of those don't work out. In fact, the reason either a regulator steps in or two parties are disputing amongst themselves, something went wrong. They lost money. Like, hey, that didn't work out. I want my money back, right? That's kind of a natural reaction. With crypto assets, really for the first time, we see the objects of those schemes being actually having value, appreciating, and being sold on their own terms away from any fundraising transactions. Although, a number of people like to say oranges are not securities, invoking, of course, the facts of Howey. That's the fact of the matter is people are selling these assets independently after they've been, if you will, harvested or originally fundraised with. And the question is, do our securities laws apply there? And if they don't, what laws do apply, right? And I think, we argue that is a lacuna, a gap in our overall regulatory framework. The underlying digital assets, in most cases, are not themselves securities, but the marketplaces in which they trade probably could use a bit more oversight.
Fantastic. Well, and I'm so thrilled that you brought up the various forms of examples in the article, beaver pelts and others. It really drives home the fact that there is a difference between the contract and the underlying asset. And, for those who haven't read it, do take a look in the article. The example of the straw range, I just love it because, it's sort of that agricultural example of, a fictitious company that develops seeds. There's going to be a finite amount of these seeds engineered. And when you plant the seed and it actually grows a straw orange, there's no opportunity for the straw orange to yield additional or create additional seeds. They have to come from the company. And so, as I was reading it, thinking through, well, what about if I don't want to grow my own straw orange and I want to, have the straw orange lab itself be, managing that and being in that ongoing relationship that kind of parallels the facts of how and I'm so glad that, you got there because that is the sort of essence, I think, of the underlying or the ongoing relationship and that managerial common enterprise continuing beyond that initial moment of when I could receive seeds in the mail. Is that sort of how did the thinking evolve on that? And it's my understanding, the paper started as really a look at common enterprise and kind of built out from there. But how did the thought process evolve?
That's great. And yes, we, along the way, as we're trying to kind of elucidate these points, it occurred, the best way is to tell a story, give an example. I think it's helpful. As you rightly say, Liz, people will most commonly invoke, right, the orange, right, from Howie, just because it's the most obvious thing. Sometimes they'll talk about, as you said, the beavers and other things. All of those assets, which are, self-evidently not securities, have different economic characteristics. They're not finite in number. They're not all created by one person or company, and they're very different. And I think, in fairness to our regulators, when we say just the simplistic and shorthand phrase, oranges are not securities, we don't really get at the essence of what makes digital assets so tricky. And you, as you just did, really highlighted some of the key factors, the fact that there's forced scarcity, right? So, you could create ERC-20s that are of unlimited quantity, and they're constantly being emitted. If you were to do that, however, the value would be much less because people say, well, heck, I don't need to buy them, in the secondary market, no reason for the number to go up. I'll just, keep getting them sort of from the fountain, as it were. And that's not how things work for a variety of reasons. And so I think one does have to grapple with those more difficult facts, as you say. Also, as with the straw orange in our example, which for those who have not yet, I'd like to think read the article, the idea is that a horticulturalist comes up with the idea of merging a strawberry and an orange into a new fruit, and calls it a straw orange. And one of the points we make in the article using that example is that right now and today, well, nobody's heard of a straw orange. Is it good fruit? Does it taste weird or nasty? Who the heck knows? What can you do with it? And new digital assets are very similar. When you create a new digital asset, it's very easy to do the code. You can go on YouTube, spin one up in 20 minutes. There's nothing difficult. There's functionally no barriers to entry. The challenging part is to convince the world that, hey, this new digital asset is kind of interesting, useful. It has purpose, and therefore you should consider buying it and owning it. And with the straw orange, it's a little bit more easy to see. Nobody knows about this new fruit, but if there's seeds available to grow it, maybe today nobody's heard of it, but you might want to buy some and think in the future they could be valuable. And so that's the purpose of our analogies, to try to sort of bring out some of the different economics of crypto assets from other more typical commodities that are in unlimited amounts and not necessarily associated with the efforts of a particular company.
That's fantastic. And, I think some of those characteristics of digital assets, in developing the networks, things like forced scarcity, in a true kind of utility token situation, it was for concepts like managing network traffic And if you had an unlimited number of tokens, literally the network would choke up or not function. Not even really thinking about using this as a device for managing the value of it, or having it be an intentionally scarce resource. So I think there's a lot of things about digital assets and kind of how they were meant in a true consumptive use kind of scenario, that make them very unique. When you and your team were looking through the case law, and I think it was like upwards of 260 cases, what were other some facts and circumstances that came out in instances where things were either investment contracts or not investment contracts? We sort of covered the post-purchase functions, and that you're more likely in a common enterprise if you have this ongoing managerial relationship and the legal contract continues to exist. But what other facts and circumstances were out there?
Yeah, no, that's great. And when you look across the cases, there are some themes that emerge as you indicate, Liz, and sort of after the main part of the article, we have about 6 or 7 page addendum that sort of just aggregates the data. There's some interesting takeaways and themes, as you say, that emerge. One theme is, again, that we go through the cases by the decades, from the late 1940s when Howey was decided, all the way through today, and we see that there were different trends in the numbers of cases that were brought. But I think because crypto assets are so prominent in regulators' minds, public's minds, it sort of seems like this is a new issue. And the first thing is, not rather a difference, but a commonality. This is a long story of people grappling with these questions. Another interesting takeaway is that when you analyze the data, one thing you find is the federal regulator, the SEC, when they bring cases, particularly at the appellate level, they actually win a tremendously high percentage of the time, something like 80+% of the time. And that's because I think regulators have been sensible and thoughtful for the most part about when cases are brought. They're really difficult facts. They're clear bad actors, and it's very easy for appellate courts to kind of find in the SEC's favor and reach that conclusion. However, there's quite a large number of civil cases where two parties to a commercial arrangement have gotten into a dispute of some sort or another. Things didn't work out the way they had wanted. And one party's counsel says, I think we was robbed, right? Nobody told us that this was really a securities transaction, and where the parties were not able to get other remedies or get, sort of recovery, by asserting a securities transaction, a disguised securities transaction, they've kind of thrown the spaghetti at the wall and sought to recover that way. Those cases work out very poorly for the plaintiffs and very well for the defendants. So it's almost flipped exactly. So about 80% of the time, the people asserting in a private lawsuit that a transaction is the disguised investment contract, they lose, and the defendants who are denying that, win. What does this tell us is that the Howey test needs to be applied very judiciously and cautiously. It's not something that's intended to sort of be a spam tool to address all types of commercial wrongdoing. We have other tools for that. It really is designed for fundraising transactions where one party is soliciting funds from somebody else, and in soliciting them, making effectively promises or undertakings to the person giving them the money, right? To the person giving them the money, hey, you can trust me with your money. I'm going to do X, Y, or Z. And then, unfortunately, very often they don't do X, Y, or Z. Value is lost. Sometimes they're outright frauds. Some of the best known cases, Glenn Turner Enterprises and Coscott Interplanetary related to a combination multi-level marketing Ponzi scheme, and that wasn't offered as a security, but in hindsight, people said people were putting in capital and doing that. Those are the cases that have done well. There's a particularly interesting case. I don't know, Liz, if you're going to want to talk about the Hocking versus Dubois case, which is the one case where something that looked at least a little bit like a secondary market transaction reached an appellate court, and interestingly, the appellate court kind of rejected that theory, but we can perhaps come to that.
No, let's go right to the secondary market point, because I mean, you know, it's the natural next step. So if you have transactions that are not in and of themselves, you know, capital raising transactions, well then, you know, kind of what else is there? And I think it's so interesting when you come across fact patterns where someone has come in the possession of tokens, you know, through some other way. They didn't buy them, you know, and it wasn't even clear to them that this was part of some sort of issuance. They have no ongoing relationship, you know, with whoever stood up the network or whoever issued the token. And I think, you know, that's the kind of thing, you know, your article has been just getting so much traction and attention from regulators and, you know, in courts where in the absence of regulation, we seem to be litigating these issues and, you know, arriving at some kind of clarity there. So, you know, I'll just note SEC Commissioner Peirce, she was talking about your proposals in her recent public speech at the Duke conference and at the library hearing, even last week. It came up in the context of an amicus argument. And, you know, the judge, you know, even though there's not an opinion out on that, there's some understanding that, you know, maybe for secondary market transactions, they would not be subject to the injunction or some of the remedy that is being argued in that case. You know, would that be a great deal of satisfaction, I think, for the industry, or just to take some of the pressure off if we could look at a difference between capital raising transactions and all others?
Yeah, no, I think it would, and I think there's really a level of common sense here, Liz. I think the law at the end of the day is just a human arrangement. It's a construct that we use to try and keep order amongst ourselves. We can reasonably predict outcomes, know what's going on, and there's a broad sense of fairness, right? That's you know, the law seeks to do. It's not a sort of I gotcha idea here. The idea is that in most cases people should inherently have some intuitive understanding of the law and how it works. Our securities laws in particular can be reasonably draconian, and there are good reasons for that. When people entrust their money, sometimes their life savings, with someone else, you know, we want people to think twice, 3 and 4 times before taking money from somebody else and using it. And we want to ensure that there's a high level of rigor. But when people exchange what we refer to as securities amongst ourselves, all of our securities laws have what's known as strict liability provisions. That is to say, if, for example, you are making markets in securities, you need to be registered federally as a broker-dealer. If you are providing a platform where people can provide buy and sell orders for securities, you need to register as a national securities exchange, or at least have an available exemption as an alternative trading system. You don't get to say, oh, I do those for securities? Snap, who knew? That's not a defense, right? And so the law needs to provide a framework by which third parties, market participants who have no relationship to the fundraising, can evaluate whether activity that they are undertaking is a regulated activity or not a regulated activity. And one of the key takeaways from the article is that the Howey test is not intended for that. None of the cases historically have suggested it. The Hogan case, which again, I'll say one more time, we can come around to it, you know, certainly suggests that at least one major circuit court disagreed with an automatic application of it. And rather, what we need to recognize is what is exactly this ineluctable element of a security, and that's it's an instrument of some sort that creates a relationship that someone can examine on its face and say, oh, I see, whether it's on a piece of paper or just simply sort of inchoate, but I have rights against an issuer or some other party, and that arrangement means that I'm entering into a securities transaction. So I use the term from our paper, ineluctable, and some people might find that a 10-cent word you gotta go Googling around for. The word means the necessary or inevitable, the thing that really characterizes something. And the ineluctable modality or way or nature of securities, we argue, is that there is some relationship, some legal relationship, some definable and identifiable legal relationship between the person that owns the asset and some other person who we would call an issuer.
And so, we talked about sort of the front end of, the time of issuance or capital raising. I'm so glad, your article also addressed the back end. And, what about scenarios where either there's an orderly wind down or other liquidation? And, this concept of this ongoing relationship and the effect that it has legally. If there is a network that has a certain number of tokens and for some reason wants to cease functioning or convert those to others, is there sort of a world or a test where something that was not necessarily before a security, so it was, let's say launched, lightly managed by a foundation, but ultimately the token was an approximation of the value of the network, not of the enterprise that launched it, probably not in the world of a security, but they want to do some kind of orderly wind down. And they want to reach out, to their token holders and, assign a value. How does that work? Is it something that can move kind of in and out in this morphing that, I think Zai in her article also addressed? I mean, how do you think about that?
Yeah, no, those are great questions. And just to fill in the blank, the Zai referred to as Zai Masari, who is formerly a Davis Polk partner, now the chief legal officer at a company called it's Lightspeed, right? Did I get that right?
Lightspeed. Mm-hmm.
Yes. Okay, good. And that's JAI. Zai, it's tricky there. So yes, those are great questions. I think it really turns on kind of the first main part of the article, which is what exactly is a digital asset in the first place. And I think that's where some of the conflation can occur. So when we talk about wind down, there's always wind down of what? So it's important to understand, an ERC20 token, which is the most typical kind of token we see, is really a bit of code that's deployed to, in the case of Ethereum, the Ethereum mainnet. Again, there are tokens on many other blockchains as well, Avalanche, Polkadot, Solana, etc. But they follow a similar sort of pattern. And if we stick with Ethereum, that'll be clear. So one can deploy a smart contract or a bit of code to a blockchain network. That's basically asking the computers in the network to store that code. And you have to pay for that. That's a transaction fee, that's gas. Once that contract has been deployed, you can cause the contract to keep a little ledger inside it, which is how at least ERC20 tokens work. And it just keeps track of addresses and numbers. It's just a little list. And if you have the private key associated with a given address, you can send an instruction to tell the network of computers, hey, lower this number, raise that number. That can never be wound down. This is an important concept. Once, as a general rule, unless the blockchain itself ceases to function, that can occur. But assuming that the blockchain does not cease to function, there's no winding down of the token. What can happen, and what does happen from time to time, is a development team that is interested in the token or the suite of smart contracts that the token relates to. Very often there's multiple smart contracts, not just one. And the development team that are just people, they may say, this is just either boring or nobody likes it, or dumb idea. Yeah, forget the whole thing. Don't want to do it. And they can just stop. In fact, generally speaking, they can stop whenever they want. It does not impact the actual token itself. There's the smart contract is deployed, the list of addresses are there. It just, maybe nobody cares. The best way you might say is if a tree falls in the forest and nobody hears it, doesn't matter. But it's really important to understand. So what gets wound down are the efforts. Now, you put your finger, I think you sort of alluded, maybe when we were chatting earlier, Liz, about the idea of a rug pull. And I think this is an important concept. So to the extent that a team raises money, say, well, look, we need $20 million and we'll give you a bunch of different tokens. That's a securities transaction. And then they may say to the people they sell those tokens to, in consideration of you're giving me value, I'm going to make some promises. I'm going to do this, 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 and this. And then let's imagine 6 months later, a year later, whatever, maybe they haven't done this, 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 and this. Maybe it's 2 weeks later, right? They haven't done those things and they just get bored and stop. And they think, I got $20 million, that's good. And so they just go off and do something else with their $20 million. The question is then, well, what legal liability is there for such activity? I think, again, in a very commonsensical application of the law, that is bad, right? You can't take money from people, tell them you're going to do something, not do it, and just laugh and leave. You will be found eventually, and you will probably be convicted of wire fraud. The fact that that can occur, and again, that's human behavior, not the tokens, that's just people taking money and not doing things. The question might be, who has standing to bring an action against the people who did that rug pull, and what is the legal relationship? And that's sort of a different question. But I think it's the idea of winding down a program is more about the relationship of who took in money and who did they make promises to versus the tokens, which don't wind down more or less ever.
Fantastic. And I'm so glad Andrea put in the chat, Light Spark is the name of Zai's company.
Yes,
Hopefully
yes,
she'll forgive me. No, I
telecommunications.
had that too. She and I were
Zai,
BB
don't watch
associates
this.
together. So
Yeah, you can later.
That's right. Well, I'm so glad we got to the topic of kind of the, less desirable bad conduct in the market, because I think there's this prevailing sort of myth that it's either regulated, by the SEC, pursuant to Section 5, it's registered, or it's crazy town. And, there is not a world where it's just those two polar opposites and extremes. I mean, you bring, to the fore the concept of wire fraud, and that there are just forms of bad conduct that are either prosecutable criminally, or where other civil liability may attach, even if it's not the SEC. Could be the CFTC under spot market fraud powers. And so if these are not securities, what next in terms of being able to discourage bad conduct, front running, trading on inside information, or just the kind of outright fraud from the kind of rug pull that you discussed? Where are the gaps in the law, if any, where we need to address and deter that kind of conduct?
I think it's an essential question you asked, Liz, and really one that any right-thinking person engaging in the space is thinking about. And look, I have my views I'll express. I recognize at that point now we're moving on across from what is the law as it stands today and into what is the policy as it should be going forward. And reasonable people will have different views about that, right? That's fair, and that's our process of making law, right? We say, well, are there gaps, and if so, what are some ways to address them? And I think as you articulated it, Liz, very well, there are two different areas where there are gaps. The first is what you might broadly call information asymmetries, right? So, in the article, we use the example again of the horticulturalist who develops a company, the Storange Labs, and they have access to information about what marketing they're doing, how they're maybe making tweaks in their sales platform, and a lot of other things that could have a real impact on the market price of the seeds. Likewise, many development companies that launch a token and put it out there, they may not be changing the code, but they still be maybe very important drivers as to the value of those assets, through a whole range of activities that they undertake. Those information asymmetries about what's going on and what they know and the information they have versus the rest of the market can produce opportunities for exploitive activity, either selling before the price goes down, buying before the price goes up, or a whole range of things. And we advocate for change to the securities laws that would require more transparency on the part of folks that raise money by selling crypto assets, which then trade in the market, and impose, rather than treating the tokens as securities, impose disclosure liabilities on the fundraiser, who really is best positioned to address those concerns, those information asymmetries. The second set of issues is really around market structure and what do we do about that? So whenever any sort of asset trades, and there's a question, well, if tokens are not securities, are they commodities? It's a somewhat loaded question, and we seek to avoid that in the paper by just saying non-securities. It's not an unreasonable conclusion that you might call tokens commodities, but really it's not a fight we choose to kind of weigh in on. But whatever they are, like our sneakers commodities, their sneaker markets, or high-end ladies handbags commodities, well, I don't know, but there certainly are markets for these non-security assets. So the presence of a market and a market price does not necessarily imply that something is a security, but there may be concerns that those markets are not being operated fairly. And so the second piece really at, I think, the federal level is to think about what is a fair way of regulating what have turned into reasonably large secondary markets for crypto assets. And again, how that plays out in terms of legislation to be determined. But I think those are the two pieces or gaps that we would like to see plugged.
Great. Well, your work and study in this area of you and your team gives a huge head start, both to the legislative process, policymakers, judicial, law clerks, just that there's the summaries of these cases out there, in addition to the fantastic, thought leadership that it brings to the community. So thank you, Lewis, and thank you to your team. I see Andrea is back, so we'll close our fireside chat here. Thank you.
Thank you, Liz.
Thank you, Liz, and thank you, Lewis. I'd like to invite Stephen and Alan to please turn on their microphones and their cameras so they can join us. And we'll begin the second part of our webinar. And I don't see Stephen yet and Alan, so I'm hoping you can.
You're going to have to turn our videos on for us.
Oh, okay, Riley, can you do that, please? And I'm going to ask Alan and Stephen to please introduce themselves. And this will be, we'll see the sparks fly, I think. And and I'm going to turn my camera off and take it away, guys.
Go ahead, Alan.
Thanks, Stephen. So I'm Alan Cohn. I'm the co-chair of the blockchain and cryptocurrency practice at Steptoe and Johnson, law firm based in Washington, D.C. Stephen?
Yeah, my name's Stephen Palley. I'm co-chair of the digital commerce practice at Brown Rudnick and also based in Washington, D.C. So if I look tired, by the way, I'll let you moderate, but if I look tired, it's because I don't know if with the screen, the blue screen, people can see this. I spent the last, you can kind of see it. I spent the last 2 days and 10 pots of coffee reading Lewis's truly excellent treatise. So first of all, we may have some intellectual disagreements, but truly impressive piece of work that I think may have, I don't know if it took as much time as James Joyce put into writing Ulysses, but obviously the product of thousands of hours of work. Next time, fewer words though, please, Lewis.
Too many words, too many notes, as Emma Davis.
I kid, it's brilliant.
So for this session, we're going to dig a little bit deeper into some of the provisions, and we're going to push on a couple of different concepts. And I want to thank Lewis because I'm sometimes accused of being too academic. So this is catnip for me. But I am going to ask Stephen, who is a much more practical person. We will get to the practicalities, but I do want to push on a couple of the different legal concepts that are in the document, because Lewis and team do a good job of setting out the principles and some of the competing viewpoints. But I think there are some things that we can dig a little bit more deeply on. But before I ask any questions, Stephen, you must have in the multiple cups of coffee and the long hours of reading, put some flags on a couple of items that you'd like to maybe push a little bit on with respect to what's written here.
Yeah, I sort of my overall view of this is that I'd have a hard time arguing on the merits of a lot of this because Lewis has literally read every case involving investment contracts for the last 140 years. And I'm just a dumb litigator, a simple country lawyer who happened to end up in Washington, D.C. But here's my simple question is, part of my practice, I'm a disputes lawyer who also has a enforcement defense practice, and I do front end regulatory advice for crypto practices. The law, I often tell my clients, I may not agree with it, but it's not my job to tell you what I agree with. It's my job to tell you what the law is. And I'm not a policymaker. I do have views on where the law should go. And this is going to be an interesting part of the conversation because I think we may share a common goal, but a different approach. But my question is, so I read through this and I thought the discussions of Kik and Telegram and Library, and we talked briefly about the recent Coinbase case that was handed down yesterday. I think they're interesting, but I scribbled in the margin, basically, there are a couple of things I scribbled in the margin, which is, okay, so you think the judge is wrong. And the next
For the
question was,
record, I don't think the judge, any of
well,
those.
let me finish. So the question is, what do we tell clients? It seems to me that your conclusion, I think, in a couple of these cases is that the judges reached the wrong conclusion, which is fair. And by the way, part of our job, in fact, our duty as lawyers, is to sometimes make good faith efforts to change the law. So there's nothing wrong with saying what we think the law should be and what an appellate court should say, or for example, in your excellent amicus advocacy in the Ripple case. I think that's totally fair game. But I look at these cases and I look at the jurisprudence that we have, and it looks to me like the SEC's position is, as a practical matter, look, most crypto tokens are in fact, even if you've got a safe and a token side letter, or you've got a SAFT, what the position is going to be, the inchoate unissued tokens that were promised contingently at the time of the issuance of the investment contract, those are part of a transaction or scheme, and those are necessarily securities. So my question, it goes back to the question: so what do I tell my clients who want to issue tokens in the United States? For the most part, I think you have to say, look, most of your tokens, if you're going to be using them for fundraising purposes, which is not the Howey test, I'll concede. If we use your concept of the embodiment theory and your discussion of that, I think the case law in the United States and the approach that you have to take is, it kind of sucks, but what you're describing is probably going to be seen as an investment contract. Now, you can take your chances with the Ninth Circuit, the Second Circuit, and the Supreme Court, but for right now, so my question is, what's the practical takeaway, basically?
And maybe let's start with the question that you noted about well, Lewis, you can start wherever you like. If you want to start at the overall question. But I think Stephen raised an important point about the embodiment theory and the embodiment theory that you discussed. So
yeah, maybe you can explain.
Maybe launch off there, what it is and why, and why you think, in a sense, as Stephen says, some courts are getting this wrong.
Perfect. So let me again, and sorry for interrupting, Stephen. I get
no, it's okay. We get excited. It's fine.
But I do want to clarify really an important point. I felt since the time it came out that Judge Castell's decision, Telegram, was excellent and absolutely rightly decided. I have just no beef whatsoever with Castell's decision. With Judge Hellerstein's decision in Kick, my beef was dicta that he placed into the opinion. Somewhere in really one line, he says the kin tokens, comma, which are securities. That is dicta because the case presented to the judge was not about the status of the token, but whether the fundraising transactions were securities, which I would agree they were. It just was unfortunate dicta. But I don't fundamentally disagree with the court's conclusions that there was a Section 5 violation by Kick. By library, similarly, the judge chose a somewhat unusual way of phrasing his conclusion, saying that the library tokens, or LBC tokens, were sold as securities, which is a phraseology he repeats 4 or 5 times throughout his opinion. And that's just a little difficult to parse because it's unclear by saying they were sold as securities. Was he trying to convey that the tokens themselves were securities, or just that the fundraising was security transaction? Apparently, in a hearing earlier this week on Monday, the judge referred to the article specifically and noted that we had not properly understood that he did not intend his opinion to be that the tokens themselves were securities. So just other than that, I had no beef with the conclusion that there were at least some fundraising transactions, even by LBRY Inc., that would have violated Section 5. The embodiment theory.
Sorry, go ahead.
No, that follow up on that.
No, please go ahead, because that's important. Discuss the embodiment theory.
So the embodiment theory stems directly from statements made by the SEC, both in the director of the Division of Corporation Finance, Bill Hinman's speech, when Howey met Gary Plastic in 2019. That's given people a lot of agita. And then more relevantly and more directly in a court filing that the SEC made in their case against Ripple Labs. In that court filing, a group of XRP holders endeavored to intervene in the case as defendants. You guys, of course, are litigators. I had the vaguest idea that that was a thing, that you could intervene as a defendant, sort of like putting your own kick me like sticker on your back. So I didn't really know that was a thing, but apparently it is a thing. And because it was a thing, the SEC was obliged to respond to that motion to intervene. When the SEC responded to that motion to intervene, they provided many good arguments as to why that was not such a good idea to allow any random person to make themselves a defendant. And they explain over the course of about 23 pages why the court should not allow that. For reasons that are not essentially clear to me, on page 24, though, they said sort of, and one more thing, and they said, you attempted interveners, you seem to misunderstand. You seem to think that we, the SEC, think that XRP tokens are securities. We do not think that, they write. Instead, and they quote Judge Pastel in Telegram, instead, we think that the token embodies the scheme pursuant to which it is sold. Is it the embodiment of the scheme? So in our paper, we, I think fairly characterize that as the embodiment theory, and really note that that is a novel theory, right? That is not something, there is no footnote at the end of that statement in their brief. Normally you would expect if you make a statement like that, you cite a case and say, well, see X, Y, Z. There is no case. We are certainly unaware of a case that would endorse the idea that some asset that is reasonably self-evidently not a security in and of itself can somehow temporarily, presumably, embody a scheme. And so we argue that it is a theoretical approach. It's the SEC that's kind of making up new ideas, not us, that is completely within their bounds. But we argue for policy reasons why it's not good policy.
So Stephen, what's your reaction to that? First on the legal sense, and then to go to your earlier prayer, does it matter? Is this a distinction without a difference?
I mean, I love James Joyce, and I don't think you mentioned at the outset that
I don't think we got into that level. They tried to tell me if we
Ineluctable,
start talking about that.
Ineluctable Modality comes from Joyce's Ulysses, which is a wonderful book. I read Ineluctable Modality to sort of mean like the truth is kind of what you see and experience. And I think that's sort of what he also refers to, the ineluctable modality, not just of vision, but of hearing, of audibility. Here's like how is a flexible test. It's always been a flexible test, and our securities regulators look at substance, not form. The challenge that I have, and I want to be clear, by the way, I contain multitudes, and if any opposing counsel is listening to this, this is an intellectual discussion, right? If you try and submit this to a judge to say that I'm contradicting myself, we're going to have an issue. But here's the thing. How he refers to contract, transaction, or scheme. And I think pushing back, I just think that the concept of embodiment, I'm not sure that it's too much of a stretch. And part of the reason for it is you talk about orange groves and chinchillas and payphones and so forth. The difference between those things is that you can take an orange and you can squeeze juice out of it. I think if you're a financial regulator, what you're going to be looking at is the reality for many people in the space is they create tokens for the purpose of creating a secondary market for trading so that number go up, not because they actually are going to create oranges or they're going to be chinchillas or payphones. So the fact that much of what has been done in the selling of tokens and creation of secondary markets is financial in nature. I think like sometimes bad facts create bad law. But I think that lends credence to the concept of these things being a transaction. I guess what I would say too is, well, let's stop there, because I think another important issue is your concept of what's the term that you use? A security issuer. What's that?
Issuer independent security.
Issuer independent security. I want to come back to that because I think that ties directly into the embodiment concept. And it also goes to the notion, I think we have to look at sort of the broader space and think about the purpose of creating tokens is often to create a market so that the tokens that the issuer holds back increase significantly in value and enrich the issuer. I think we can't walk away from that when thinking about this. So I guess my sort of common sense view of this, and maybe common sense doesn't work, embodiment, it kind of sounds like a transaction or scheme to me. I think it fits in there. And my concern is that sometimes it feels like we're it's angels dancing on the top of a pin. I'm not sure that the intellectual argument captures the practicalities, and often that's what the trial judges are looking at. They're seeing people who've enriched themselves. Not the case. Like, for example, I think library is actually a very different case. And one of the tragedies in that case was that's actually technology that probably had more use than just about anything. You can maybe make the same argument with kin and kick. But sometimes, I think we have to look at, if we're looking at the ineluctable modality of the visible, we have to think about the visible. We've got to think about all of the visible.
So, Lewis, what's your response to that?
Well, I got to give like all the gold stars and kudos, because I don't know, wherever you pulled the one, I love, trying to turn that concept of the ineluctable modality of visible in the other direction. So I love that. I think it's fantastic. And that's showing true litigator skills. So just props, huge props there. However, I would push back on the practicalities, and I do want, and this is just immensely important. I think those who have worked with us and our firm know our position, but there's a lot of folks listening or maybe watching on recorded lines. I could not agree with Stephen more to say that what do you do today, February the 3rd. It's a little bit like in baseball, or at least before video replay, right? You may think you're safer out, but the umpire makes the call. Right now, our umpire has been very clear, the Securities and Exchange Commission has been very clear about their view that the vast majority of tokens are inherently securities, whether used in fundraising or, as you say, later on sold in secondary transactions. I think any lawyer disagreeing with that at this point for purposes of advising ongoing activity would be reckless, just reckless. So
caveat noted. Caveat noted.
So I say that, yes. So I just say that is, you must abide by the rules of the road. You may think 35 miles an hour is a silly speed limit to have, and the roads are built for something else. You go 36, you're probably going to get a ticket. So I think that's really important that everyone understands. So that's my first one.
But I do want to say, look, American roads are built for speeds a lot higher than that. And Stephen made the point, maybe bad facts are making bad law here. Is that the case? You've made the argument in the manifesto that issuer independent securities is bad law, and that embodiment is bad law.
Can I touch on that? I mean, I know we're short on time, but I think it's a really, really brilliant argument. The notion that secondary market trading shouldn't be regulated the same way because there's no independent contractual relationship between the holder of the token and the issuer. It's an interesting argument, but I look at that, and I don't want to give anybody ideas, but I look at that and think about it as a litigator, and I typically defend these things, but you've got equitable theories, unjust enrichment, constructive trust. There are also contract theories, implied contract, third-party beneficiary, somebody being a donee beneficiary. I think the law adjusts to a wrong. So if you've got a situation, and rescission, while it's statutory, rescission is an equitable remedy, right? Where you don't actually need to have direct privity. So I think I can't overcome, like, as we sit here today, I can't challenge your reading of the existing case law. It's just too friggin' comprehensive. And you've done a statistical analysis and it's brilliant. I look at it and I think to myself, well, could you come up with theory? I think the answer is yes. And the problem is, what's the maxim about, equity, I'm going to paraphrase, but equity is not going to allow a wrong to stand. And you come back again to the challenge that sometimes I think to judges, it will appear that the entire purpose of creating the token is to create an independent secondary market for self-enrichment. I think in that context, the brilliant legal theory that there is no such thing as an independent, say it again, issuer independent token, I think it might fall against the shoals of I don't know, sort of practicality. Where I come down on this too is I'm not suggesting, I don't actually think securities law makes sense for what is, in this case, technology risk. I don't think the RIAA, I don't think any of the statutes any of the proposals are getting. I think we need to have a bigger conversation about regulating technology risk. The securities laws from 1933, 1940, those were dealing with risks that could be answered by a disclosure regime, right?
But let's put that to the side, because that is another important piece of the dialogue. I do want Lewis, you to respond to that argument of is this, is the court ignoring doctrines, or is this form over substance, or as Judge Castell pointed out, the economic realities here trump the fine lines of the doctrine.
Yeah, thank you, Al. And Stephen, those are fantastic points, and almost all of them I'd actually agree with. I think where the difference is, it just needs to be teased out a little. What we're talking about are not the culpability of the fundraiser. We're talking about two parties who are strangers to that arrangement. The only thing we're concerned about is if you and I meet in a bar and I say, hey, I got some XYZ, can I say Coin? Probably not, just keep it there. I got some Coin here, and what do you think about buying it from me, right? We have nothing to do with the project. We're not participants in the project. We're just two guys at a bar. And I move from my wallet to your wallet those Coins. The only question we're addressing is that a securities transaction? And the very practical point we are making is that we need to be able to ascertain from the facts that are available to us whether that transaction is a securities transaction or not. The fundamental flaw in the embodiment theory and the fundamental flaw in the argument you were putting forward as between two third parties is that we do not have access to all the kinds of information that courts have assessed over and over and over again when evaluating when a particular scheme or transaction is an investment contract or is not. As I know, 80% of the time, courts have found that as between private parties, there is no investment contract transaction. And the courts have, of necessity, looked at private information that third parties cannot determine. Moreover, I think the cases pretty clearly read that the determination as to whether a scheme is or is not being embodied is at the time of transaction. Yes. So, for example, let's say there's a project team and they've been, doing all of the entrepreneurial efforts, and we're about to enter into the transaction. And rather sadly, the plane that has all of them goes down in the ocean, 10 minutes before we execute our transaction. Did it stop being a scheme because there's nobody scheming anymore because, they're in a better place? Moreover, even if that happened, let's say one of them survived, there was a wing and, it was like Castaway. And then, and then eventually they find him in the volleyball, and then he comes back and then he starts up the scheme again. It's like, hey, 3 years on the desert island. Now I'm back and now I'm starting the scheme again. Like, does the token become a security? It is a fundamentally unworkable standard. And I think we can get to the same policy outcomes in other much less unworkable. So my practical answer is it just doesn't work when you get to thinking about it, because how does a market participant know when the scheme has started, stopped, and restarted?
So Stephen, respond to that, because Lewis has cataloged kind of the law relating to secondary transactions.
Yeah, so I'm going to quote James Joyce again. If you can put your 5 fingers through it, it's a gate. If not, it's a door.
You're telling me. I love it.
Sorry. I almost became an English professor, so I'm allowed to do that. And I went to law school. Look, you make a point about, there are no disclosures. How can it be a security? And I guess the answer is the fact that there are no disclosures is maybe itself a securities violation. I don't think that gets you. I don't think that necessarily is the thing that determines whether that secondary transaction is is a securities transaction. You have to look at again, is it a door or is it a gate? It's gonna depend. Now, the things I think we also, and I think the SEC has accepted this. It's not like there's been a regulation. We wouldn't expect that, but things can change. That's again, common sense, right? So sure, the desert island concept, yeah. The problem with that is, and this is where law needs to adopt, like saying we should fix our securities regulations so that we can address the risk of the use of a digital token later doesn't really make sense. We're thinking about this in the wrong way. And again, I come back, this is my own, you have your white whale to mix literary metaphors in this paper. My white whale is the notion of technology risk, broader concept of technology risk. I'm not sure that securities laws make sense. We actually had a conversation years ago, I think before you wrote this, that stuck with me, and you said, look, in other countries, like in South America, this was something that would be governed by consumer protection regimes. And what's interesting is, and you know this, I know, and I'm sure you know this too, the SEC almost didn't come into existence. Initially, securities were going to be regulated on the federal level by the FTC. So I think one of the questions ought to be, from a policy standpoint, who's the right regulator? I'm getting too far off the mark.
But
I think I disagree with you maybe about that transaction you discussed in a bar, but only in the abstract. We'd have to look at facts and circumstances.
Well, so let's jump forward to something that you did note, which is that Congress is beginning to wrestle with this. And there are a number of bills that were pending at the end of the last Congress that are either been reintroduced or going to be reintroduced. But really only one of them tries to tackle this true definitional issue. What's a security? What's not a security? What information has to be disclosed as part of that? And that's the Responsible Financial Innovation Act that Senators Lummis and Gillibrand introduced. And this introduces this concept of ancillary assets, that to try to draw this distinction, Lewis, that you've said between the underlying asset and the transaction through which it is sold. And then it gets to Stephen's point also about information that needs to be disclosed to make this work. So first, Lewis, do you want to amplify anything that's in the paper? And then Stephen, and like your thoughts on, is that heading us in the right direction?
Do you want me to comment on sort of that as a policy outcome, or just policy or not? Yes.
Yeah, I mean, does that solve some of these issues that you've raised regarding the ability of people in secondary transactions to understand what they're buying, or the lack of information, the information imbalance, or just the fact that market participants of all types, the situation we're in now, because it's so facts and circumstances dependent, and there's such different articulations, is just rife with uncertainty.
Yeah, well, I think Senators Lummis and Gillibrand did an amazing job with that, and a tremendous. You want to talk about a lot of work. Senator Lummis's office in particular was instrumental in just really powering through a lot of issues, and credit is very much due. I think on this particular point, Alan, I think it really brings out, I think, an important point, which is, as Stephen rightly said, if there's a failure of disclosures, kind of who's responsible, right? Who bears that responsibility? I would argue it's not the third-party market participants; it's the entity that raised the money. By getting a benefit, you have a burden. You raise money, and exactly as you said, Stephen. We all see the same basic facts, right? People generate many tokens really to see number go up, and there's no getting around that. I don't disagree. I think a better policy outcome would be to say, hey, look, if you raise money and you were able to do that through creating some token that's trading around, you should have disclosure obligations to the general public. And that kind of stems out of a longstanding rule article in our securities laws, Section 12G of the Exchange Act, which imposes disclosure obligations on companies, even if they never undertook a public offering. It basically says if you have more than 500 unaccredited, it's changed around, but now 500 unaccredited or 2,000 accredited holders of your securities, equity securities, at that point, there is enough public interest that even if you did everything right, you never did a public offering, you have disclosure obligations. And this would be sort of a variant on that.
Stephen, your thoughts on that?
So the challenge is that, so as to the statute, the proposed change to the law would mean that certain types of ancillary assets, they would be governed by the CFTC as opposed to the SEC. I think the challenge is you're changing from a disclosure regime to a registration regime. And I'm not really sure that necessarily makes sense. Again, I'm just a simple country lawyer, not a policy guy, but I don't know that like, should we really be applying, should we be applying the Commodities Exchange Act to digital assets? It just seems.
Well, again, I just wanted to.
Yeah, but
before we get to that, yeah.
The way the bill stands, the Exchange Act would be modified to impose securities law obligations on issuers. So,
Yeah.
And I think it's also important to note, and this goes back to some of the substantive discussions, that this concept of ancillary assets and disclosure up to a point where it's no longer necessary seems to be trying to address two substantive issues that come up in the cases and that, Lewis, you've raised. Number one is this distinction between the underlying asset and the mechanism by which it's sold, and really very much, the SAFT as an example of written instrument versus underlying asset. And so the provision tries to get at, well, let's codify that. The other thing it tries to do is it tries to pick up, right? So it tries to pick up the theme from Bill Hinman's speech, the Gary Plastics speech, that decentralization is a key element. And it's basically it basically says there's a threshold before which something is not decentralized, and therefore there may be efforts of others and common enterprise issues and information asymmetry. And then you reach a point where then those issues go away and it's no longer necessary.
Yeah.
Is that and that animates a lot of the piece. Stephen, what's your thought on that?
I want to actually I represent, we have exchange clients, and what Lewis is concerned about secondary markets, it directly impacts exchange clients. I can tell you, you all know this too, we probably represent some similar overlapping clients. The exchanges all want to comply. And they've tried to, a number of them, they've got broker-dealer licenses, they're, trying to register as national securities exchanges. They're I think there's actually a desire from the industry to have registration that allows them to list digital assets. So I think that's the direction. And I would actually criticize the regulators for not working with those platforms. Now, as to the notion of decentralization, I mean, it's just it's so damn mushy. What does it mean? Sufficient decentralization. I've run the analysis on plenty of assets, and the best you can usually come up with is, maybe you give it which is not satisfying. And clients don't want to spend a lot of money for a lawyer to say, well, I've looked at it and on a scale of 1 to 10, it's an 8. Also, law firm general counsel doesn't really want you to say that either. So there's I think a better registration and sort of risk managing regulatory regime. It not, in addition to giving people certainty and providing consumer protection, it also creates a regulatory moat, frankly, for larger actors in the industry. I'm not sure that the decentralization, I'm not sure you can take something like that. I actually think Commissioner Peirce tried to do that, and also LexPunk with Reg X has tried. It's just for whatever reason, it hasn't gotten any take up by regulators who are more interested in enforcement actions than in actually moving forward with useful and helpful regulation. I'm taking Lewis.
So let's Yeah, no. Let's pick up that point, because in a sense, decentralization is being used as a proxy for the end of the common enterprise or the end of the efforts of others.
Sure.
Lewis, is that a,
Absolutely.
based on your analysis, is that right?
Yeah, I think that people's instinct, Director Hinman's instinct was spot on. I think he just placed, for expedience or otherwise, placed the burden on the wrong party. A third-party market participant is not best situated to determine when that decentralization, whatever exactly means, has occurred. The person who should have the burden is the entity that raised the money. And really, so there, what we're testing not is whether it's an exchange, a broker-dealer, a custodian, whether they're engaged in a securities transaction or not, because it's, again, we'd all agree at a minimum, very difficult to ascertain, as Stephen noted. Rather, the entity with perfect information is the project itself, the people who are working on that and continuing to provide development. So I think they can absorb that burden and are best placed to absorb the costs of making that decision, where the outcomes are just providing disclosures. So they have an easy way of kind of rectifying the situation. For a third party, you don't have an easy means. Like, just as you rightly observed, Stephen, you can't easily become a national securities exchange. But for a project, providing disclosures that would address the information asymmetries that you would otherwise have in the securities laws, that's reasonably easy to do. And so it's sort of a commonsensical approach. Let's place the burden where it's best borne.
But it's not enough. But as you point out, with the Web3 Foundation's kind of unilateral declaration of morphing, it's not enough for those with the perfect information to make that determination. Sure.
Under our current law, that's right. I mean, you have to change the law to make that more clear, which is what Lovells Gillibrand would do.
Okay, so we have about 3 minutes left. Stephen, I want to give you the opportunity to ask your last most pressing question of Lewis about the treatise.
Oh gosh, last most pressing question. I don't know. I'm kind of curious. Like, what's I'm putting on my hat and I'm thinking about like my futuristic hat. Like next, maybe this is your role to ask this question, Alan. But like, where are we in 5 to 10 years? That's the question that I'm trying to sort out. I can tell you, I think where this should go is we need to have legislation that is as significant as the 33 Act, the 34 Act, the Trust Indenture Act, and the 40s Act, more significant than Dodd-Frank. And I think that legislation needs to encompass technology risk associated with what you call fungible digital assets, but I think it will likely include something more. I don't know if we're going to get there. I mean, the reason that we got to the 33 Act and the other acts is the Depression. So, but that's kind of where I see an end state that makes sense. What are your thoughts?
So Lewis, does all this doctrine that you've described, is there an arc that takes us to a place that's workable? Or as Stephen has said, do we really need something fundamentally different?
Yeah, I think we do need something different. So Stephen, I think we broadly agree. I think, I draw, folks who have heard me talk before know, I draw from some historical events. One historical event I look at is the experiment in the United States with alcohol prohibition in the last century. It's very, very difficult to tell people not to do something that they want to do. And there's just way more folks than there are people to enforce against folks. And very often that produces bad outcomes. So I think a framework would start with incentives and give people a practical way to comply with the law. Most people want to comply with the law if you give them a means. If you give them an outright prohibition, they just think, it doesn't make a lot of sense. Another example I draw upon is with file sharing in the early 2000s. As the Apple came out with the iTunes store, there was a practical way not to violate copyright. I think a legislative path would kind of look in that direction and give a practical means so most people could abide by the law.
Yeah,
looks like we're getting the hook there. Are you playing us out now with the music?
I'm going to jump in. We have about a minute. And in that time, I'd like to thank all of our participants here, our featured attorneys, Lewis and Stephen and Alan and Liz, who had to head out early. And of course, Global Blockchain Business Council and the International Journal of Blockchain Law. I'd like to thank you all for participating, and thank you so much. And Alan, thanks for your great questions. So that's it. We'll see you all again next time. Take care, everyone. Stay warm.
Thank you
Bye-bye.
so much.
Thanks
Yeah.
all.